Welcome to the broadcast. My name is Marty Schenkman, and I'm joined by a great panel of speakers who I'll introduce in a minute. Susan Reach Winters, who's a brilliant matrimonial practitioner, Sandy Glazer, who is an estate planner and litigator in Michigan, and Jonathan Blotmacher, who I hope needs no introduction. And for the next hour, although we kind of tend to speak a little bit longer than our allotted time, forgive us, we'll see what ideas come up and how long it goes. But for approximately the next hour, we're going to talk about estate planning and matrimonial matters. The subject area is vast, so we're obviously not going to cover all of it, and we'll focus on a number of different topics that we advertised and that the speakers thought were of interest. And I'm sure we'll go off on some valuable tangents as we discuss. A couple of quick comments on the webinar. The PowerPoint is available now. You can download it from the web console. You'll see the handout tab. Click on the little caret, and there'll be a little download button. You can print it or download it at your leisure. When we send out emails for the program, the emails have a link to where you can download the PowerPoint before the program. After the program is over, it may take us a week, but usually it's only a day or two. We post a recording of the program and all materials on schenkmanlaw.com/webinars. It's actually a library of probably closer to 100 webinar recordings you can access at any time. I also know that Peak Trust and Interactive Legal post the materials to their website, and I'm not sure if CSG, Susan's firm, will be posting it to their site. So there's several ways you can get the PowerPoint if you did not have it yet. We do not give out CLE or CPE, but you will be sent a certificate of attendance. The certificates of attendance are generated automatically by the system, so there's nothing we can do if it doesn't read the way you want. And finally, if you have questions, all the speakers' email addresses are on the last slide. I encourage you to email the speakers directly rather than posting questions to the web console. It's just very difficult with 4 speakers in a brief hour or so time to answer questions. We have 2 sponsors for today, and I want to turn it over first to Vanessa Kanega from Interactive Legal to say a word.
Well, thank you very much, Marty. Hi, everyone. As Marty said, I'm Vanessa Kanega. I'm the CEO of Interactive Legal, and I'd like to thank you all for joining today and to thank the panelists for presenting what I'm sure will be a useful and practical webinar as always. If any of you would like more information on Interactive Legal, please email us at the email address shown on the screen or visit our website at interactivelegal.com. We provide automated document drafting software and other resources for elder law and estate planning attorneys, and we'd love to hear from you. So thanks very much.
And I apologize, Vanessa. Interactive has some very interesting options and different language for encouraging or mandating that heirs get prenups. There's some very interesting provisions there, and I should have included some samples, but we did not. But everyone should know there's some good stuff there on this topic as well. From Peak Trust, our second sponsor, Nicole.
Hi, welcome everyone, and thank you for attending today's webinar. My name is Nicole King, and I'm a trust officer here at Peak Trust Company, and we are pleased and honored to be able to sponsor today's presentation. I'd like to take this opportunity to tell you about Peak Trust Company. We serve individuals, families, and their advisors by offering tax-favored situs in either Alaska or Nevada. We are a full-service trust company, and we offer flexible and customized administrative services for all types of trusts. So if you should have any questions, feel free to give me, contact me either by phone or email. And as Marty said, you can find these materials on our website as well. So thank you.
Thank you, Nicole. As has been my custom for a number of years, we try to feature different charities on each program to bring to the attention of the advisor community the incredible causes that are out there that you can personally help, as well as encourage clients to help and make plan gifts to. And it's an honor to introduce Kevin Sander from Wounded Warriors Family Support. Kevin?
Hey, thanks so much, and it's a pleasure to be joining you today. Yeah, Wounded Warriors Family Support, we're a 501c3 nonprofit charity that supports our combat wounded veterans and their families. We're one of the highest rated nonprofit charities throughout the country. As a matter of fact, Good Housekeeping rated us as one of the top 50 of all charities in the country. And we support military families, specifically of the combat wounded in all 50 states, Puerto Rico, and Guam. We have a lot of great programs that help improve their quality of life. So you can check us out at www.fs.org. If you have any clients out there who might be considering supporting a military charity, leaving stocks, bonds, estates, what have you, just look us up. We're a great organization. We do the best good possible to support our military heroes and their families.
Thank you, Kevin. A wonderful cause, and I encourage you all to not only encourage clients to look into Wounded Warriors, but yourselves as well. So let's get started with the program. Some of what we're going to talk about is going to be basic and obvious to all of you, but we'll hopefully take it to much deeper, more practical applications that will be helpful to everyone, regardless of what discipline you're involved in. Trust is certainly one of the most powerful tools in planning. Jonathan, I know, often comments that he is one of the most I'm not sure of the word, but advocates perhaps ever. And the default approach that he generally recommends, and I think probably most practitioners at this point agree with, is that everything should be left in trust, and preferably robust long-term trust. But traditional trust drafting can often fall short of providing the desired results, although many trusts, perhaps the vast majority of trusts out there, are still what we would call traditional old-style trusts that pay income out, mandated, or that end at a specified age, and so on. So what we're going to try to talk about is how you can better craft trusts and what to do with existing trusts, and there's a lot that can be done, even if they fall short of the mark now, in light of matrimonial considerations.
Marty,
yeah.
Let me just say a couple words. I am the most pro-trust lawyer in the entire world, and I'll battle anybody on that, and I will win, because it's the best thing you can do. The other thing I want to mention is that for every one of us, your biggest creditor, your most likely creditor you're ever going to have is your spouse. Half of marriages in the United States end in divorce. And that person whom you adored, that you planned your future with, has now become your biggest financial enemy. And in fact, there was a survey done by the New York Times about 10 years ago where they asked people a bunch of kind of bizarre questions. One of those was, do you personally know someone whom you're confident is going to go to hell? 23% of the people said yes, unless they'd been divorced, and then it was 60%. And, I mean, think about that. I don't care if you're a brain surgeon, you're a plaintiff's lawyer, you're an accountant. Yes, you may have claims that come in from your profession. But if you're married, or if you ever cohabit with anyone, your former lover may be your biggest financial enemy. And it's very, very bad. And there are things you can do to protect yourselves. And even more so, and we'll talk about some of these, for your children and your grandchildren. It's a very loving thing you can do. I just can't emphasize it enough. You really need to make sure that you use trust to the maximum extent possible to protect not just from common creditors, like, you know, someone who's lent you money or someone with whom you've had a car accident, but it's also with respect to your spouse and your former spouse. Susan, I'm going to ask you a very, very important question, all right?
Sure.
What is the difference between in-laws and outlaws? Outlaws are wanted, Susan.
I love it.
Keep that in mind.
Jonathan, you just made my case, which is every marrying couple needs to consider having a prenuptial agreement, and every married couple needs to think about having a postnuptial agreement prepared. And in every single prenuptial or postnuptial matter I'm involved, I want my team to include a trust and estate lawyer so that we can layer those agreements with trust. Every divorce case I'm involved in which a trust is involved, I also involve a trust and estate lawyer because undoubtedly the non-beneficiary spouse is looking to get to the assets in the trust and or the income in the trust for support purposes. So I need someone with expertise in the matter of drafting and interpreting trusts in those cases.
Jonathan, if I could
Sandy,
add,
maybe you can.
it's not just the grantor's spouse who may become the creditor of the estate or trust estate. It's the beneficiary's potentially ex-spouse who could become a creditor of the estate. So when drafting these trusts, we have to think about the long-term effects of holding property in trust and what rights you want to give to beneficiaries, because they may have implications to your children and your grandchildren should they get divorced.
Absolutely correct, Sandy. And as Marty said, in interactive legal, we have special provisions. And I just want to give one. Susan, I completely agree with you. Everybody should have a prenup or a postnup, but we know the vast majority of people don't. And it's very tough to go to your spouse and say, I know we're going to be married forever and we're getting married in, you know, God's plan, but I want you to sign this prenup. Very, very tough to raise. And what I've done for many, many decades now is create trusts which state that the descendant can continue that trust for his or her spouse when she dies, but only if they've entered into a prenuptial or postnuptial agreement, which the trustees determined is satisfactory to protect the financial interests of the beneficiary. And I had one case, and Susan, you may get into this, where they very wealthy family, kept postponing having their daughter go ahead and sign a prenup. Finally, she said something to him. He hired a lawyer. When the lawyer sent the signed agreement in, he said, this has been signed under duress because it was only a month before the wedding. So I wrote back to the lawyer and I said, I want you to take a look at this trust. If they get married, my client, the wife, can go ahead and continue this trust, which was about $1 billion for her husband. And she has a power of appointment to continue part of the trust if she predeceased him, but only if they've signed a prenuptial agreement, not under duress, and it's satisfactory to the trustees. The next day, I got a letter from a lawyer saying that original statement to you was an error. We find this fine. My client is signing it not under duress. So that's something that parents can do for their children and grandchildren, because they don't have to say to their fiance, gee, I want you to sign this. It's just, sweetheart, in order for us to enjoy this property and for me to be allowed to continue the benefits of this trust for you in the event of my death, we've got to sign this prenuptial agreement. And I have never had any fiance on the other side say no. And do you know why, Marty? Marty doesn't know this, but it's always about the money. And everybody is greedy except for Sandy's clients. She gives them a test and they have to be completely immilionominary for her to represent them. But for the rest of you who represent people as greedy as Marty is, and let me tell you, he is a greedy SOB, you want to make sure that you have that stuff in the trust to protect the children and grandchildren.
So Jonathan, I would say that I actually had a family who had those provisions of the trust. The children thought it was overbearing, so they entered into a prenuptial agreement, provided it to the trustee, and then terminated the prenuptial agreement because nothing precludes parties from deciding that they're going to terminate the effectiveness of a prenuptial agreement. So I just mentioned that to think about while I recommend having prenuptial agreements, and in Michigan we have some issues with postnuptial agreements in terms of divorce, you have to think about all the consequences. So just having a prenuptial agreement may not be sufficient. Having a postnuptial agreement may not be sufficient. Having language in the trust itself, a protective nature may not be sufficient, but adding all these layers on is probably the best approach that you can utilize.
I'm definitely fine. I'm definitely finding more and more parents like myself who have children of marrying age are contacting me to have me prepare prenuptial agreements for their adult children. And they're basically saying to their adult children, you have two choices. One is I'm going to freely give to you while you're married, but you have to have a prenup because I need to know that if you get divorced, whatever I give to you will stay in our family and not wind up in your spouse's hands in the event of a divorce. Or don't sign a prenup and I won't give you anything. I've never had anybody, any adult child, choose the latter. They always choose to enter into the prenup.
I think the take-home point, which is really something that we've done for years with asset protection, and I think it was Sandy's term, layers. You want to have the prenup or post-nup if a prenup wasn't done. You want to take precautionary measures to assure the non-commingled nature of immune or separate property. You want all assets possible in trust solution, and we're going to talk about it. Before we go on to the next slide, Sandy, maybe you just comment for a second about how in an equitable distribution jurisdiction, even if you do everything right, court may make a disproportionate award of marital assets to compensate for what may be protected in a trust.
Sure, Marty, because I also do family law in addition to estate planning and probate litigation and trust administration. I am often called into cases that deal with trusts as an expert in the divorce arena. So it's not uncommon where we might protect the assets that are in the trust and establish the separate nature of the trust asset, but have a judge, and I'm in an equitable division jurisdiction in Michigan, say, well, when I look at the marital estate, it's simply not enough. And it's not equitable to equally or come close to a congruent division of the marital estate. So I've had judges grant the entire marital estate to a party, saying you've got these separate property assets that you can rely on to live on a go-forward basis, but your spouse doesn't. And there's not assets in the marital estate that are sufficient under the facts and circumstances presented. And so the existence of that separate property can actually work against the individual where they otherwise would have been sharing in the marital estate, but the fact that their parents may have left them separate property assets or they acquired all the assets before they got married result in really a disproportionate allocation of the marital estate to the other spouse. So in fact, I have drafted prenuptial agreements to address the existence of the separate property interests and to create a formula that takes that into consideration. Because most of my clients, when they leave an estate to their children, let's say, or they have separate property they're seeking to protect, don't want that to be used as a sword against the beneficiary, such that they don't benefit from what's accumulated during the marriage.
I actually just had that exact result occur in a divorce case I handled, and it was a double whammy for the beneficiary spouse because not only did she get less of the marital estate and her husband got substantially more of the marital estate, but then when it came to alimony, the court imputed interest income on the principal of the trust assets and used that to offset alimony. So she also got less alimony than she otherwise would have been entitled to.
So I bet all the people on the call on the webinar are wondering, well, why should we do all the trust planning you're going to be talking about? Don't you still feel net it's a much better advantage in most cases?
Yes.
Or maybe somebody wants to comment, because I think you've just kind of made the case for doing no planning when we all think you should do planning, because I've seen the opposite. I've seen where we've had significant assets held in various trusts, either for inherited assets or slats or spats, DAPs, which we'll talk about, that even though a disproportionate allocation may have been made of marital assets, that net, the client who'd done the planning, and it was well in advance of the divorce, it was some of it well in advance of the marriage, that net, they fared much better than had they not done the planning.
And I think every case stands on its own facts. And the facts in my case were very poor in terms of the trust that was in play. I think if you prepare these trust documents in the way that you've suggested to protect against these outcomes, you're in much better shape. Although we've often said, when you're in a court of equity, you're in a court of anything goes. So you could do all of the appropriate trust documents and all the appropriate planning and still come out with a result that some judge somewhere thinks is fair, which of course is a subjective standard. I still think it's better to have the documents than not have them, so long as they're properly prepared.
Right.
And depending on the terms, Marty, of the trust and the other instruments you may enter into and the facts of your case, you're much better off having the separate property than having a judge say, well, even though it's separate property, we're going to include it as a divisible asset, because in Michigan, they can invade separate property. But if the trust is drafted in a way where the beneficiary cannot access and utilize the trust, and we're going to talk about a case where there was not a vested interest, or, in essence, where you've got pot trusts or wholly discretionary distributions. Though that type of drafting can protect the assets of the trust, isn't it better to protect the assets of the trust than subject it to division along with the marital estate in some circumstances?
And if you're doing a prenuptial agreement and you're preparing a trust at the same time, and the prenuptial agreement refers to and attaches as a document the trust document, I think that's the best of all worlds.
Yeah, we're going to come to that. We're going to talk about some of the recommendations for prenups and how to handle all of this and the amount of disclosures. What about planning prior to marriage? Susan, you want to make some general comments about premarital planning?
Well, as I said before, there isn't a client I've ever had that didn't wish, because he was going through a divorce, that he had a prenup. It makes the divorce case much less costly, much less emotionally draining, because the prenups clearly define what is separate property and what will be considered separate property that's acquired during the marriage, and what is marital property in the event of a divorce. And I think that relying on a court, I think, as we've just discussed, to make that decision is very, very risky. I think a couple getting married without talking through and addressing all these issues beforehand and understanding what the other person expects in a marriage, and if in the event of a divorce, is of tremendous value. And again, properly done, a prenup will be held to be valid. And just like the provisions of a trust will not be able to be invaded if the trust planner keeps in mind, like Jonathan said before, this marriage very well could end in divorce. I think you're correct, Jonathan, that people don't want to think that way, but with the divorce rates what they are, you need to.
I always say to my clients, it's easier to negotiate in love than in hate. So when you address these issues on the front end, it's like going pre-marriage counseling. You address financial issues. I suggest that clients address how you're going to deal with separate property, the issues of how the parties are going to support each other during the course of the marriage. While we can't address child support or bar that, we can address financial obligations that the parties will undertake with regard to each other during marriage, as well as I often suggest we enhance that to what a person will get on debt, because if you have a successful marriage that goes all the way until one of the parties dies, it's always a good idea to leave them more than what you would have to leave them if the marriage failed.
Let's go on to the next topic. We were going to talk a little more detail about prenups. We've covered some of it. Susan or Sandy, do you want to make any other comments on slide 13 that we haven't covered?
The only thing I would say there is clients often say to me, why do I need a prenup if the law defines what is exempt from distribution in the event of a divorce? And there's a lot of reasons why you do, not the least of which is you're identifying the premarital assets very succinctly in a prenuptial agreement. If you are a business owner, you want to also exempt any appreciation on the value of the business that you're actively participating in during the marriage, which most laws don't allow you to do. There'll be less of a need, if any need at all, for a forensic accountant to value any increase if you have a prenuptial agreement that clearly spells that out. And it also allows you, a prenuptial agreement also allows you to commingle assets while you're married and still get them back if you wind up in a divorce. So for example, the prenuptial agreement could say something along the lines of, if you decide as a married couple to purchase a vacation home, for example, and one party puts in 25% of the purchase price and the other party puts in 75% of the purchase price from separate assets, in the event of divorce, the one who put in 25% gets 25% back, and the one who put in 75% gets 75% back. So it allows the married couple to do things jointly, so to speak, without worrying about commingling it and losing its exempt status and having to trace it as part of a divorce, which of course is very expensive.
Always a mess. Not only is it expensive, it's a mess, and it's always seems to lead to arguments and because it's just very difficult years and years later to reconstruct anything. One of the common, it's not relevant to our topic of trust, but let me just say it because I've seen it wrong so many times. A very common provision I see is where one spouse brings into the marriage a securities portfolio, and the matrimonial attorneys will provide that those assets will be considered separate, but the income from them will be marital. And how do you possibly handle that? First, you got to define what is income, but second, from a practical perspective, what you can do is just simply set up the brokerage account so dividends and interest, if that's what's defined to be income and not capital gains, are just credited to a joint account at the same firm, and you avoid all the grief that Susan has mentioned about commingling and having a forensic accountant come in and try to sort it all out, which is never a great situation. The final point on slide 13 I just wanted to make is doing a prenup is not only helpful from the standpoint of avoiding the issues that Sandy and Susan have been talking about, but it can also backstop some of the asset protection that you're doing for the client. So for example, if you have a couple and both spouses are working as surgeons and they're both concerned about liability exposure, as they will be, maybe one of the things you do is provide for that their income tax returns will be prepared as married filing separate returns. And from those separate returns, the accountant will then aggregate and prepare the married filing joint, which provides let's say a lesser tax cost, and that'll be filed. But if you mandate in the prenup and then in the engagement letter with the CPA every year a buildup from separate returns to joint returns, it may be much more supportable that if there's ever a suit against one spouse, that the joint tax return not necessary or permissible to give to a claimant for the other spouse. You may thereby protect from plaintiff's counsel seeing the overall marital assets. Susan and Sandy, do you guys want to comment?
Something that Susan said, and that is, if you have a closely held business interest and you take the position that the spouse who had that interest going into the marriage is going to keep it at all appreciation, in some states, a prenuptial agreement needs to be fair and equitable when you enter into it, as well as when you seek to enforce it. So you need to think about how are you going to address the fact that that spouse is actively working in that business and its growth may be attributable to what would otherwise be considered marital efforts. And in that regard, we go back to not only fashioning how you equitably address that while still protecting the business at the time of divorce, but also adequately defining how you're going to determine any increase in value that may be attributable to the marital efforts in that formula. And that goes back to making sure you have full and adequate disclosure in your prenuptial agreement, not just I have ABC Corporation and I think it's worth $14 million today. You need to be able to have sufficient backup for how you arrived at that value, because if you've created a formula that addresses the increase that occurs during the marriage, you need to make sure that you can compare apples to apples in the valuation to determine what is going to be divided.
What I've started doing in the disclosure section of prenuptial agreements is adding a narrative talking about the fact that it's likely that the business will substantially increase in value due to one spouse's work efforts, or that there's a future inheritance that will be substantial coming to one of the spouses. And I think if you include some monetary consideration for all of those waivers by the other spouse, you're more likely to have a prenuptial agreement that is determined to be fair and equitable and not unconscionable.
Let me mention a couple of points here. Susan raised the question of clients coming in and saying, since the law tells what is separate and what is marital property, why do I need this? Well, one, the couple may move, and the kind of property you have when you get divorced may change radically. If you have a couple, for example, that lives in Rhode Island and moves to Texas, you're going to go from a separate property regime to a community property regime. And many states like Arizona and California have something called quasi-community property, which means that anything the couple acquired, if they move to California or Arizona, becomes something called quasi-community property. You need to be aware of that. In addition, if your client's children or the client moves to either Massachusetts or to Connecticut, you will find that the breadth of assets that the court can whack up is unlimited. Even if you've received an inheritance the day before your husband leaves you, you received that inheritance from your parents, the court can whack that up. And in Colorado, even the increase in value in a trust can be whacked up. So your parent creates a grat for you, which initially has a very small value for you, but by the time it ends, it's now been very successful. The court can whack that up and give part to your spouse. In addition, there will be different rules at divorce. The states have great disparity in what your spouse gets if he or she survives you. All of those things need to be covered. Marty, back to you.
Susan, were you going to make a comment before we go on?
No, I can talk about this slide if you'd like.
Sure, go ahead.
So you need to think about at least two things in a prenuptial agreement. What happens if you get divorced, and what happens if you die while married? And a lot of prenups are prepared for people getting married for a second time with children from a first marriage, so that there are considerations in that regard. For example, if you're asking someone to waive the right of election, you're doing that because you want to leave your entire estate to your children from the first marriage. I think that's fine to do, so long as, again, you provide some monetary consideration to your current spouse, such as a life insurance policy or some income producing trust for the spouse's lifetime. The concept being it has to be fair and equitable, and it can deal with equitable distribution, it can deal with maintenance, it can deal with as I just said, post-death rights of election and other death provisions. It can deal with retirement plan benefits. The only thing it can't deal with is child-related issues. And as long as all of those issues are addressed fairly, and the other aspects, the other factors necessary for a valid prenup, which we'll talk about, I guess, in a minute, are met, you have everything you need to avoid an emotionally and financially costly divorce.
But
How do you guys demonstrate fairness? What do you do to help demonstrate fairness when you're doing an agreement?
Well, as I just said, I think for every right that's being waived, every right that's being given up by one spouse, that spouse who's giving it up should get some consideration in return, perhaps not of equal value, but of some value. So for example, you could give a spouse who would otherwise not be entitled to alimony or spousal support until year 5, you could start the alimony in year 1 or 2 and have her waive something else, but point to the fact that she was getting something that perhaps she would not get in a court of law if it was just a typical divorce case. So as long as you can show there was some consideration for these rights being given up, I think you're in a much better position to prove that it's fair and equitable. And it has to be grossly unfair to one spouse. Unconscionable is the term that we use in New Jersey in order to qualify as not being fair and equitable.
So in Michigan, look, my philosophy, and I tell this to clients all the time, pigs get fed and hogs get slaughtered, right? So if you end up being too extreme and push the envelope, right, you run the risk that the agreement you entered into will not be abided by a court. We complicate that by a case we have in Michigan, and Marty, we've got a future slide on this, but it seems apropos to address it now, is the Allard case. And in that case, the court said, we the court, has certain statutory rights that you as parties cannot waive. We don't care what you put in your prenuptial agreement. We have a statutory right to arrive at an equitable resolution. And if you've ended up waiving the entire right to spousal support and waiving the right to invade separate property, and you don't have a sufficient marital estate, those are the kinds of situations where the court is likely to say, we're not going to abide by this. We're still going to invade your separate property despite the terms of your prenuptial agreement. So I think you want to try to stress test to some extent, is it fair and reasonable against what is the court likely to do at the time you're entering into that prenuptial agreement, and based upon the foreseeable progress that may be made during the course of the marriage.
So let's tackle another topic. I'll introduce it and ask Jonathan to comment. So one of the things that should be addressed in a prenuptial agreement is the use of the dessous. So if you have a wealthy spouse and a not so wealthy spouse, the wealthy spouse may want to get the deceased spouse unused exemption from the not so wealthy spouse. And one of the reasons that this is important right now as we speak is if consideration is paid for that, if it's not calculated as a formula or percentage, it could be quite problematic. And this may be something that many of you need to review with clients. And for example, if the Sanders bill for the other 99.5% is enacted and the exemption amount goes from 11.7 down to 3.5, if the moneyed spouse committed to give to the children of the non-wealthy spouse $1 million for the benefit of getting the dessous, and now the amount of the dessous drops from 11.7 to 3.5, what do you do about it? Jonathan, maybe give a little background on how to address a dessous and what people might want to do, and then you may have some comments to build on what I just suggested could be an issue for some with pending legislation.
As probably everyone knows, if you die and you're married, you can basically allow your surviving spouse to inherit your unused estate tax exemption. Now, you do that by using a complete marital deduction at all. If you have taxable bequests, that's going to use part of your estate tax exemption. But if you don't have any estate tax due because of the marital deduction, you can leave your entire estate tax exemption to your spouse who will inherit it. And this is important right now, because if I drop dead today, my spouse could inherit my entire $11.7 million exemption and make it part of her own. And even if next year they reduce the exemption down to $3.5 million, as Senator Sanders has proposed, Betsy would continue to keep that $11.7 million. So it's very valuable. And if you have a 40% estate tax, that $11.7 million can save about $5 million in estate tax. But you've got to then file a return and make the election to have the exemption transferred over to the surviving spouse. There are cases where someone has died and his or her kids are asked by the surviving spouse's family to file an estate tax return so that the survivor can inherit it. They said, no, we're not going to do that unless we're paid. Now, that's going to cause a tremendous amount of animosity between the two surviving family sides. And so that is something that should be covered in the prenuptial agreement. It's really critically important. So, Marty, that's just got to be done. And if it changes, well, you could have a formula about how much would be paid. It will be equal to a third or 10% or whatever. So the surviving spouse's family can go to the children of the deceased spouse and say, here's 10% or 20% or 25%. You must file the return and you must elect for the exemption to pass over to the surviving spouse.
I think also, Jonathan, the benefit is litigation avoidance, because in the cases that came up, at least one jurisdiction mandated that the 706 be filed in order to preserve the unused exemption. The issue then becomes who's going to bear the cost of preparing the return when there is no economic benefit to the decedent's estate, but there is an economic benefit to the surviving spouse's estate. So when you end up addressing those issues in the prenuptial agreement, you really are helping both sides to avoid future litigation.
I think one of the cases actually found that the surviving spouse, the right or the ability to get the dissue was an interest in the estate, even though that surviving spouse wasn't named as a beneficiary, and they permitted it to be enforced. On slide 16 and 17, we're not going to go through it, but there's a sample provision that addresses dissue. But the one point I wanted to make to just emphasize what I had said earlier, if let's say a Sanders bill gets enacted and the exemption amount rather drops from 11.7 to 3.5, if there was an agreement made where a fixed dollar amount, say $1 million, was agreed to be paid in exchange for getting the portable exemption, what do you do if now the benefit of that bargain has changed dramatically? The 10 million plus inflation adjusted exemption is reduced to 3.5. Just something to keep in mind. You may want to make sure that any existing pre or post nups that deal with the dissue have a percentage or formula and not a fixed dollar amount. And there's a sample that you can go back to. Susan, you want to comment, and then Sandy chime in on some of the risks of prenups? We don't need to cover duress because I think Jonathan talked about it. Some of the other issues?
Well, again, fair and equitable is a term like pretty. It's in the eyes of the beholder, and we're in a court where anything goes. So a court could find that an agreement is not fair and equitable just based on whatever reasons they feel they need to come up with in order to back into a result. As we talked about, the best you can do is make sure that there's consideration given for every right given up. I find one of the most important aspects of prenuptial agreements is the full and fair disclosure of assets, liabilities, income, both earned and unearned. And aside from a financial statement and several years of tax returns, you need to offer professional appraisals of properties. You need to offer professional valuations of businesses. You definitely need to produce the actual trust documents that are in play. A lot of people are very uncomfortable doing that, but I think it's essential in order to meet this factor required to have a valid and enforceable prenup. Just one thing about the factor of duress is that I have gotten to the point where I recommend to every prenuptial client that they videotape the execution of the prenuptial agreement, only because then we have preserved for eternity the demeanor of the couple signing the prenup. And generally, they're in very good moods. They're very happy. They look like they're doing it of their own volition because they're about to get married. And it is some protection, not absolute, but some protection down the line if someone claims they were signing under duress, but their demeanor on the video says otherwise.
So I would counter that point, Susan, because I've had a lot of people come in to sign those documents and they're in tears and they're very upset and they feel like they're being forced to sign it, even though they've heavily negotiated the terms and obtained a lot of concessions and they're represented by counsel. So I don't tend to videotape them, but I highly encourage people to have separate counsel and for my client to start the process very, very early and keep track of all the drafts that go back and forth and the changes that have been made and the accommodations and the concerns that have been addressed during the process. And I find that is really what's important, and not the demeanor on the day that they're signing, because that can be a mixed bag. And I've experienced that. So I don't really want to give somebody else the ability to second guess what that demeanor is or how, and interpret how the people are acting on that date, or whether somebody's overbearing or not, or somebody's very meek and mild and therefore was capitulating. I'd rather have the testimony of the attorneys. I have the attorneys sign a certificate that they verified that their clients were signing freely and voluntarily, that they've explained their rights to the clients. Those are the things that I prefer to do rather than videotaping. And the only times I videotaped is when a party absolutely refuses to get counsel and comes in to sign without an attorney, then I will record it. Oftentimes it's not a video, it may be an oral, just a recording on my tape recorder when I go into the meeting. These days, recently, I have them on video because we've been signing them remotely. You know, when we're doing them remotely, I record the signing and I keep it in the client file.
Couple of quick comments. So I also like both spouses to pay their respective attorneys. I don't like the moneyed spouse to be paying the other spouse's attorney. It just doesn't look right. And one of the things, and I'm curious if Susan or Sandy have seen anything on this, but I've seen a number of situations where the moneyed spouse comes in and has, forgive the expression, I'm not sure how to put it, but a very astute, heavy hitter matrimonial attorney from a major firm. And the non-moneyed spouse has somebody that does house closings and auto negligence cases. And oh, all right, well, I'll do that prenup. Where, you know, there's such disparity between the capabilities of the two attorneys that it really makes me wonder if that will really suffice as independent counsel. Any thoughts or comments?
Well, I would say, Marty, I often have the moneyed spouse guarantee the fees of the attorney and let the non-moneyed spouse pick whomever they want to represent them, because it's important that they have adequate independent counsel. The mere guarantee of the fee doesn't negate the independence of the counsel selected. It's just a mechanism for making sure that the non-moneyed spouse can have adequate representation.
And you can include a provision in the prenuptial agreement that says that even though the moneyed spouse is paying for the non-moneyed spouse attorney, it is not affecting his or her ability to enter into a fair agreement or take positions, whatever. But going back to what you said before, I 100% think that it's imperative that each party have their own attorney. But if I'm representing a client who, as you explained, is in tears and hysterical and doesn't want to sign an agreement, I don't think I'm going to allow them to sign the agreement without, at the very least, a letter from me to the client saying, I don't want you to sign this agreement because you're clearly under duress. You clearly don't want to sign this. And that, even if she goes ahead and signs it, that letter is part of the file and subject to discovery if anyone challenges the prenuptial agreement down the line.
Well, one thing I'd like to reiterate that Susan mentioned, you have to make full disclosure. And very often the spouse who's wealthy, there are trusts for his benefit, he won't want to do that. But then I say, well, what do you think it's going to be like if you get divorced? Everything is going to be disclosed. Every will that your parent and grandparent had in effect, every trust, every deal, all of that will be disclosed. You're not going to want it at the time that you get divorced, but it will be. Now you're happy, you don't think you're going to get divorced, disclose it. And you can ask that people keep things confidential, but I go on the side of maximum disclosure.
The other thing, Jonathan, is if you coupled your prenuptial agreement with a DAP, right? So if you've created a DAP, a self-settled trust in a state that recognizes them, and you happen to live in a state that recognizes self-settled trust for asset protection purposes and permits them to avoid the claims of your spouse as a creditor, I think you need to disclose that DAP and its contents as well if you then enter into a prenuptial agreement.
Amen. Amen.
I think that's one of the most underutilized techniques in premarital planning. If a client is going to get married a year from now, 6 months from now, and obviously you want it well in advance, they can set up a self-settled trust. And I would go further than what Sandy said. Even if they're not living in a self-settled trust jurisdiction, you set up a trust in one of the trust-friendly jurisdictions, Michigan, Connecticut, Alaska, Nevada, South. There's 19 jurisdictions that permit self-settled trusts. And you fund that well in advance of the marriage. And you disclose that with the full trust instrument and a balance sheet of the trust on the prenuptial agreement. I think it gives you an outstanding belts and suspenders. If ideally, if the wealth is inherited, it should go into trust so that it's a third-party trust. But if the client's getting married and has significant wealth, and some portion of that wealth is going to be preserved as separate property, why not give it or sell it or give it to an incomplete gift self-settled trust to try to protect it? It's now held by an irrevocable trust, pre-marriage, and fully disclosed.
So if you have, we started out talking about more traditional trusts, historical trusts, that didn't have the types of protective terminology that we see today in terms of wholly discretionary distributions. It may have provided for rights of withdrawal or outright distribution at certain ages. So let's say your client inherits during the course of the marriage, but not while the marriage is on the rocks or there's any problems evident in the marriage. And so nobody's thinking about divorce in the immediate future. In some states, you can then create a DAP with the consent of your spouse and thereby take that distributed inheritance and provide protection for that by executing a DAP during the course of the marriage. So I don't want people to only look at DAPs as protective on the front end before you get married. It may be a way of correcting the situation, because in some states it may be difficult to decant an already vested interest where the withdrawal right or right of distribution has already occurred.
So DAPs should really be looked at. I find them not addressed nearly enough in matrimonial planning. And hey, by the way, folks, if where we're sitting right now today, any client that hasn't used up their entire estate tax exemption, and there's a chance of it dropping from 11.7 to 3.5, and they have immune assets that you can corroborate are immune, why on earth not try to evaluate making gifts of a large part of that to a self-settled trust, get it out of the estate, protect it from marital issues, and you've also used up your exemption to protect that as well. So you have a very strong non-marital reason for doing it.
I would just add one caveat. Senator Chris Von Holland of Maryland has put in a bill which would say that whenever you make a transfer, unless it is to a grantor trust that's included in your estate, which means you have not effectively used your exemption, all the inherent gain in the asset will be recognized. So you've got to be pretty darn sure, and I'm one of those who is in this camp, that his retroactive effective date to January 1, 2021 will not stand. But I think you have a duty to warn the client. The safest thing to do, use your exemption by transferring cash. And if the rules don't change dramatically, you could later substitute the other assets that otherwise would have gone in for the cash that's there.
Thank you. Good, all good points. The benefits on slide 21, I'm sure everyone knows. If you create a non-grantor trust, you may be able to reduce or minimize state income taxation. If you can shift assets out of the estate, obviously subject to the issue of the Von Holland proposal that Jonathan mentioned, you can perhaps minimize estate taxation. And if the Von Holland bill is not enacted, something like the Sanders bill is enacted, getting a grantor trust grandfather could be huge. GST tax minimization, intergenerational planning, multi-generational planning, except to the extent it may be limited by some of the current proposals. Lots of benefits, creditor protection, and so on. So there's benefits well beyond just the matrimonial benefits for trust. Sandy, I think 682 is something that's important to talk about. Why don't you take a couple minutes and just tell me to advance the slides if I should?
Yeah, so because I know we're already at the top of the hour and we had so much we wanted to cover, but in the 2017 Tax Act, certain benefits from an income tax perspective were eliminated in terms of the ability to shift income from one spouse to another in the event of divorce. Many people are aware that Section 71 benefits were eliminated on a go-forward basis for in the event of divorce, so that alimony would not be deductible. That there are certain rules, including a modification of a pre-2019.
Sandy, I think you're echoing. Can you make sure you don't have a phone on and it's on computer?
I don't have anything here, so.
Okay, keep going then.
I think it's coming from you, but that's okay.
Susan, why don't you try muting just in case it's.
So Section 71 benefits the ability to have the recipient spouse declare the alimony payments and have them deductible to the payor were impacted, but also under Section 682, you used to be able to shift in the event of divorce the income tax consequences of a trust. If your spouse is the beneficiary, the spouse continues to receive distributions from that trust, they would be taxed on that trust. So you may have created a trust, an irrevocable trust already, but you're not divorced. And now you get divorced in 2021. Well, the income tax consequences associated with that grantor trust are going to stay with you as the grantor, even though your spouse is now receiving all the income. So it's an important aspect of addressing in any divorce proceeding how you're going to deal with that. You may even want to address it in a prenup. You may want to address what's going to happen if grantor trusts are created. How will you address it? You may want to consider trust protectors if you're doing those trust slats now. A lot of people are doing slats in order to use up that exemption that Jonathan referred to earlier and make a present gift today that gets the assets out of the grantor's estate, but still provides benefits for the family unit because the spouse can go to the trustee and seek distributions. So that would be considered a grantor spouse if the spouse is getting benefits out of that trust or has the ability to get benefits out of that trust generally. And that will fall into the 682 trap. So you want to be cognizant that that issue exists.
Okay. Let's talk for a minute about the case mentioned on slide 25. Generally speaking, we've viewed that if you have a trust that has a sprinkle power and there's a number of beneficiaries and it's discretionary distributions in the discretion of the trustee, that the interest, the ill-defined interest of the beneficiary should not be attached in divorce. In this particular case, the lower court held that even though there were 11 beneficiaries, and it was a discretionary distribution, that they awarded 1/11 of an interest in the trust in divorce, and then awarded the divorcing beneficiary spouse 60% of that. On appeal, it was noted that the trustees were manipulating the distributions and stopped making distributions during the course of the divorce to try to protect the husband beneficiary. But the court on appeal found that it was a mere expectancy, so it was not subject to division. But that really poses a challenge to a lot of what we had assumed as to how trust provided protection in a divorce, that if you have an independent trustee with discretionary distribution standards and a class of beneficiaries, that expectancy could not be attached and divided in divorce. So even though this court case ultimately held that way, the fact that the lower court had divided it does raise some concerns. Jonathan or Sandy or Susan, do you want to comment on the concepts in that case and what people might be able to do?
I generally recommend fully discretionary trusts. If you have an interested trustee, then you may want an ascertainable standard, but give the independent trustee, a fully discretionary ability, and so we were planning on talking about the fact that perhaps the interested party trustee could be removed by trust protector, by other trusts, or pursuant to the terms of the instrument as an automatic removal if they're involved in divorce proceedings. The fact that you've got what I call a pot trust or sprinkling rights is much more protected than a single individual, but there are also problems with pot trusts and sprinkling powers in terms of who you have to report to and disparate interests, and people may feel so-and-so got more than they got, and that's a problem, and it can create conflict within the family. So you have to balance all those interests when you're drafting these trusts. But I think that, discretion without a standard can be helpful, at least in the divorce arena and for creditor protection. But there may be reasons why you want to have an ascertainable standard, or you may negotiate as part of the prenuptial agreement a mandatory right of income or a 5/5 power or a certain base amount of support that'll be provided. So I think you have to look at them drafting in a totality, and you have to look at your jurisdiction, but understand that jurisdictions can change and that can impact how these rights will be viewed.
Anyone else want to comment? Susan, I think you should mute when you're not talking. I think your computer is generating the feedback, and just unmute when you speak. I think despite this case, the clear approach is to have a discretionary distribution standard. I clearly prefer having, whenever possible, an institutional trustee, not a family member, and whenever possible to be in a trust-friendly jurisdiction with laws that are as protective as possible against matrimonial and any other claim. That's the most you can do. You can't really do more than that. I think in this case, the fact that distributions were changed in the wake of the divorce and in light of the divorce was a negative factor, but I'm not sure what you can do. Sandy, we've talked about DAPS already. Is there anything you want to add to using DAPS as a marital planning tool?
I would point to the Klabaka versus Nelson case. We've got it in the materials, but given how limited our time is, I think the slide itself basically covers what we were going to cover. And
Yeah,
I would mention, Marty, and you and I and Alan Gassman wrote an article about DAPS that should be readily available to people if they want to delve into this area a little deeper.
Yeah, I think the key point in my view is that many matrimonial attorneys are not aware of the flexibility and the power of premarital trust planning, or even after the marriage, but certainly premarital trust planning using a self-settled trust to shift assets into a protective structure makes a world of sense. Now, one of the things that doesn't provide that level of protection, but can be useful from a matrimonial perspective, is a very simple tool that's used all the time in estate planning. I just don't see it adapted very often for matrimonial planning, and that's the virtually ubiquitous revocable trust. And the idea of taking assets that were given to the child, because most clients don't listen to Jonathan's mantra, everything should be bequeathed or given in trust, not outright. And once a client has something outright, what do? Well, certainly a self-settled trust, even post-marriage, and Sandy said you might want acknowledgement of the spouse if you're doing this post-marriage, can be very beneficial. But even just funding a revocable trust can be useful. Susan, do you want to comment on this technique? Because I know we've worked on something like this for mutual clients in the past.
Absolutely. I mean, it is a great second layer to a prenuptial agreement. We worked on a case where we did it as a postnuptial agreement, or part of a postnuptial agreement, or an amendment to a prenuptial agreement, which you can also do during the marriage. And I think it helps, again, in terms of segregating those assets that you intend to deem separate in the event of divorce. And it helps with identifying them down the line. And if you've done any commingling, it helps with the tracing issues because you've got a very definable starting point.
I would add one thing, because in some jurisdictions, if you are permitted to do a postnuptial agreement or an amendment to a prenuptial agreement, if you are not in one of the uniform law states, or your state has not adopted a statute akin to that, you may need to provide consideration that you don't need on a prenuptial agreement. So I don't want people to forget that issue when you're addressing either an amendment, a modification, or entering into a postnuptial agreement.
I wonder, would you guys think that, let me just give the context. So a client had assets in their own name that were clearly identified as separate property in the prenuptial agreement. And what we did is we created a separate property revocable trust and put those separate property assets that were enumerated in the prenuptial agreement into that trust, really just to create a separate accounting entity and assign a separate tax ID number to it, just to reduce the risk of the commingling that just so often seems to permeate divorce situations. I don't know that changed. It didn't seem to me like it changed one iota of anything other than creating a separate accounting entity to minimize the risk of commingling. Would Susan or Sandy, do you think you'd even bother? And we actually did give, I think, consideration in the form of life insurance, additional insurance for it. But do you really feel it's deemed a modification, or you would need consideration for that kind of planning?
So it sounds like there wasn't, if you had just done that estate plan as a means of segregating the separate property, consistent with the terms of the prenuptial agreement, I would say to you, Marty, no, you don't need consideration. But if you then went and modified the prenuptial agreement in a way that affected somebody's rights by that modification, then I would answer that differently.
And I would agree with Sandy, and I think, Marty, it was your suggestion in our case to give the spouse consideration for signing the amended prenup. And what's the downside? You know, there's no downside, and there very much could be an upside because you are asking her, in this case, to acknowledge that these assets are separate property post-marriage. So I think she was doing something for the benefit of our client, and therefore was entitled to some consideration.
Yeah, and I think, again, the take-home point is this is not a complex, costly, or sophisticated plan. We've all seen in matrimonial cases just really difficult commingling situations. And if you can separately identify assets, if you can put them in a envelope with a separate tax ID number and have a separate tax return, you're just minimizing the risks of the commingling that creates so many headaches. And I agree with what Susan's comment was, which is why I suggested it. Why not give some consideration? You're just shoring up and eliminating another potential challenge, as Sandy explained. But the idea is that you can take a lot of the very basic trust and estate planning that we all do on a regular basis and just tailor it and apply it in creative ways to bolster the matrimonial planning that we all do. We're getting a little long in tooth on time. Maybe what we should do, since we're not going to obviously get through everything, why don't I ask each of you, maybe just starting from right to left, Jonathan, to make some comments or planning suggestions or thoughts that we haven't gotten to that may be useful for the audience. You're muted.
I think that what Susan said at the beginning is great sense. You need to just not do this stuff alone. You need a good lawyer who's experienced in prenuptial or postnuptial agreements, and you also need an estate planner. There are some who can do both. I think Sandy is in that territory, but I know that when I did this, I would couple up with a really strong, person that was very familiar with matrimonial matters. It's critically important, and as Susan stated, if you have a prenuptial agreement, the divorce is going to be less bitter. You don't want your client to be in that 60% which say, I definitely know someone who's going to hell when he or she dies.
Sandy, any?
I would indicate that it's not just on the planning stage, but you have to think about if you're a trustee or an administrator and you've got beneficiaries who are going through a divorce. Look at decanting, look at the option of changing situs, look at, it's important to have good trustee language, replacement trustee language, trust protector, trust director language, so that it's not the beneficiary who's taking an action immediately preceding or during a divorce that might be viewed by a court to adversely impact the right of the other spouse. It's much better, based on the case law that we've seen, to have the trustees acting independent of the beneficiary if they're taking an action that could impact the rights of beneficiaries. And for those of you who are not familiar with the rights of beneficiaries in other states, know that there are some states that are far more protective and do not make exception for spouses or children when it comes to considering the assets or income of a trust for support purposes. So knowing that that exists in some jurisdictions but not in other jurisdictions can make a huge difference in the outcome of somebody's divorce case.
Sandy, I'm gonna call on you again. I think there's a really important topic. I don't even think it was in our materials, but I know you have a lot of knowledge on it, and I always turn to you for advice in these areas. Maybe make a couple of statements about dual or joint representation and what practitioners need to be careful of, because that so often comes up in this context.
So if you're doing an estate plan for a couple, and then one of the spouses comes to you afterwards and says, I want to change the estate plan, but don't tell my spouse, you're going to be in a conflict situation. And I was attending a meeting last night where I got into a debate with another matrimonial lawyer who said, look, let's say the client came to you from joint representation and they tell you they want to change their estate plan to eliminate their spouse. Well, if it was part of a cohesive plan, should you really be modifying the plan? And should we as estate planners, if we're doing a plan representing the couple, include language that there shouldn't be an ability to modify even a revocable trust without providing notice to the spouse? Now, I don't think that's really the standard of care, but he mentioned he's seen some malpractice cases starting to come up where the estate planning attorneys entered into joint representation and did not provide some notice language, and then the other spouse was able to change the estate plan based on the way it was drafted and undercut the plan they jointly created. So I don't know that I agree with it, but I think it's worth noting that people are being creative in this area. But you always have to identify, is there a conflict of interest? And when you've got multi-generations, as Susan said, when the parents are saying, I'm not going to give you any more unless you do a prenup, and I'm not going to give you anything unless you do an estate plan that protects the assets that you're receiving. You know, we may have conflict situations. They may be waivable, but we need to make sure we make disclosures, that we have to be considerate of the engagement letters we enter into. And we have to be cognizant of the types of advice we give people. Specifically, let's say you're doing a SLAT now as part of a family planning situation. If you've got a floating spouse provision in there, which Marty likes to talk about, create a floating spouse because it provides flexibility. Well, you better really reflect upon and advise both parties what it means if you get a divorce and the spouse gets remarried. Who's going to be the spouse under that instrument? What that floating spouse provision means. And you may well want to have both spouses represented in that instance, because it's hard to give advice about what somebody should or shouldn't do that won't be against the interest of the other spouse.
Thank you. We got to be careful. It's complicated, and it can serve to bite you. And we should make sure that in addition to protecting the clients, we also protect ourselves, because trying to help a client and finding yourself in that kind of compromising position is not a good deal. Susan, why don't you make any concluding remarks, and then I'm saving a question to try to stump you after you're done.
Oh, great. I would just like to say that there's many times when a potential client comes to me for a consultation for a divorce, and it's too late in the sense that there was no prenuptial agreement signed before they got married. There was no postnuptial agreement entered into during the marriage, and there's poorly drafted trusts in place that we know ahead of time are going to probably be accessed in some way, shape, or form by the other spouse. And as Sandy mentioned, there's techniques such as decanting and transferring jurisdictions and the like, but we have to be cognizant of the fact that divorce courts, judges sitting in divorce courts, are looking for litigants who are suffering from what they like to call divorceitis. And they're taking steps to plan their divorce. And the courts don't like that. Often it colors the judge's impression or opinion about the veracity of a litigant when they're deemed to have done or engaged in some divorce planning. But I believe that there are techniques that can be employed to make sure that that's not the conclusion that the judge breaches, such as someone mentioned, having the trust protector or an independent corporate trustee make those decisions to decant or change jurisdictions or the like. So we need to be, taking care of people who did not properly plan for a divorce, but be cognizant of those elements if and when we get to divorce court.
So what are some of the biggest mistakes that you see that have affected your clients that trust and estate lawyers have made over the years? Like what do you see as some of the common issues? I'm sure outright gifts has to be the number one thing. Like, why on earth do that?
Outright gifts, also in terms of designating the spouse and not having a floating spouse provision. And then the ex-wife and the current wife, and who's the spouse? Is it who was the spouse at the time the irrevocable trust was established, or is it the spouse now? There's just no thought. Just like when people get divorced, they're not thinking about, when they get married, they're not thinking about getting divorced. When people are preparing their estate documents, they're not thinking about getting divorced. Or maybe they are, and they come back to Sandy after the fact and say, cut her out. But I think that there's got to be that same sort of recognition that people who practice divorce law have all the time, which is this very well could be a situation where you get married and it doesn't last forever. And the mistakes that are made are with regard to the control and access that the beneficiary spouse has to the trust, or the regular distributions to the beneficiary spouse during the marriage, and then they get divorced and the other spouse is saying, well, that was always part of our income. I've had cases where it's the only income coming into a marriage the entire time of the marriage. No one worked. They lived off of one spouse's trust income, and then they're getting divorced and the beneficiary spouse says, well, that's not guaranteed. I might not get that in the future. Well, we're not going to get very far arguing that, because it's been the only income that this family has lived on during the marriage. So all those things need to be taken into consideration at the time these documents are being drafted.
So
I
just
would
a
add to
couple.
that, Marty, we see a lot of trusts that were like what I call pot trust or sprinkling power trust, and they have a HEM standard in them, even if they don't have an outright distribution. And now you're getting divorced, and the spouse who has custody of the children, who may not be the beneficiary, the spouse may no longer be a beneficiary or may never have been a beneficiary. They're going to the trustee now and saying, you know what? Health support and maintenance of these children, you need to make a distribution to me as their custodial parent for their benefit, because I don't get enough support to be able to maintain the children's lifestyle. So you may not have intended for that ex-spouse to get a benefit under the trust, but you may inadvertently create a right for them to get distributions if the court finds that the trustee is abusing its discretion and not making a distribution when you don't have a wholly discretionary trust. And I agree with Susan, a lot of it's the administration of the trust during the course of the marriage. If you're constantly making a set amount of distributions each and every year, you've always done it, you've always paid these expenses, even when you've got a discretionary trust, that can create a problem when you get to divorce court.
So let me just give you a few thoughts or things that I've seen come up that were kind of interesting. One of the things that I always find fascinating is when matrimonial counsel has us review an estate plan or a trust or a transaction to see if there's a way we can pick apart what the moneyed spouse did. I had a note sale transaction that the husband had done in one case, and they had made zero down payment for it. And the way the transaction was structured, had they put $1 of separate property into the trust or $1 down payment that was from separate property, I could have seen the argument that it was really remained separate property. But if there was zero how do you show that it was really retained as separate property? So just be mindful when you're structuring seed gifts to a trust with the amount of a down payment on a transaction, how that's structured. Another thing that I think we need to all be aware of, floating spouse clauses, and Sandy did a great article on it. It's really a very relatively new area, but certainly one fraught with issues. I've now had a couple of situations where when clients were negotiating prenuptial agreements, we had the new spouse agree to waive her rights, or his rights, as the case may be, as the floating spouse. So even though this family trust named a floating spouse, I agree I will not accept benefits as being a floating spouse. So just something to think about. Be mindful of doing joint rep letters when you have a couple. We talked about decanting. I think Susan and Sandy both talked about it. Decanting is certainly preferable to, say, a non-judicial modification, just to expand on their comments, because in a non-judicial modification, the spouse beneficiary of the trust may sign off consenting to the non-judicial modification. Institutional trustees often prefer a non-judicial modification because then they are not making the decision as they would be in a decanting. But once you've gone from decanting into non-judicial mod, you have a situation where if the beneficiary spouse is consenting, might the court view that more negatively in terms of marital planning, especially if a divorce is imminent or in process. If you have no choice but to do a non-judicial mod, some statutes, and I think Delaware is an example, permit, instead of consenting to the non-judicial mod, just saying you don't object. Now, I can't really tell you that non-objection is better than consent, but it certainly sounds like it might be. A couple of other cases, then I'll stop, where we had existing trusts and the moneyed spouse had really salted away most of the assets in this trust, but it turned out in reading the boilerplate to the trust, and what I actually did, because we got so used to reading trusts and looking for certain provisions that our minds kind of assume what the provisions are going to be. I sometimes read the trust backwards to forward just to see if I'm missing something, because you can't read through it the same way. And I found a really weird provision that the beneficiary had the authority to get a loan from the trust without interest. So my argument to attack the trust where the moneyed spouse, the husband in that case, was protecting assets, is if he can borrow everything out of the trust and never pay interest, why are these assets protected? He has unfettered access to them. So, sometimes the swap power and loan power and some of the things that we insert have really unexpected ramifications in a matrimonial action. So, take a creative eye when you look at this, because it may just be the mechanism that's needed to help change the result in the case. Anyhow, I want to thank my speakers, Jonathan Blattmacher, who had to get off, Sandy Glazer, Susan Reach-Winters. Thank you all for joining us. I hope that even though it was a little off script, that you got a lot of interesting ideas and practical ideas, and I wish you all good luck. Thank you.